Hi, I'm attorney Ellen Wright, coming to you today from the Wright Family Law Group in Tewksbury, Massachusetts, with some critical things that you absolutely need to know if you are the unwed father of children in Massachusetts. Dads often face an uphill battle when it comes to family law issues, but for unmarried fathers, the situation is usually worse. Ideally, a father who wants to be involved in his child's life will be able to work out a custody and co-parenting arrangement directly with the mother. Sometimes, though, things are more complex and it doesn't always go that smoothly. In Massachusetts, mothers and fathers have equal custody rights. But for children born to unwed fathers, fathers first have to establish their paternity in order to assert their rights as a parent. There are 3 ways to establish paternity in Massachusetts. The first is for the father to voluntarily sign the birth certificate. The second is for him to file directly with an administrative agency like the Department of Revenue Child Support Enforcement Division. Or the third is to file directly with the family and probate court and to request a court order. For the second and the third options, fathers are going to have to submit to a DNA genetic marker test. What does this mean for your situation? Well, if you are the unwed father of children in Massachusetts, you are essentially left at the mercy of the mother until paternity is established and the court enters orders in your case. Until the court enters custody orders, the mother has statutory, legal, and physical custody of your children. This means you will have no right to access medical or educational information or participate in decision-making concerning your child. Let's look at a quick example. John and Mary are boyfriend and girlfriend. They have a 6-year-old daughter, Chloe. They have lived together in an apartment in Lowell, raising Chloe since Chloe was born. They both work but participate equally, bringing Chloe to doctor's appointments and extracurricular activities. Even though John is Chloe's father on the birth certificate and Chloe has John's last name, there are no court orders regarding custody of her. Mary meets Ken and decides to break up with John. Mary moves in with Ken, who lives on Cape Cod, which is 80 miles away from Lowell. Mary takes Chloe out of her school in Lowell and enrolls her in her new Cape Cod school without telling or asking John. Because Mary has custody of Chloe by operation of law, there isn't anything John can do to stop this long-distance move. As you can see, many times unwed parents cohabitate together in the same household as a family raising their children. Sometimes they do this for years. Like John in our example, dads in this situation often have no need or desire for family court orders because they have unfettered access to their children and participate in the day-to-day living decisions. Because they participate regularly, bringing children to doctor's appointments, bringing them to school, and making day-to-day decisions for them, they often don't realize that they don't have any rights until they have to go to court and ask a judge to establish them. Whether you're an unmarried dad-to-be or you've been living with your girlfriend, raising your child together for some time, an ounce of prevention is worth a pound of cure in the family court world. Click the link below to download our free cheat sheet that has tips and tricks on how to stack the odds in your favor if you think you might be headed to family court on a custody battle. Also, feel free to reach out to us on our website at wrightfamilylawgroup.com or give us a call at 978-851-2291 to schedule your free, no obligation custody strategy session.